Thank you for everybody for attending, logging into this special I3 session for prison and assisted reproduction. Should people in prison have access to fertility treatment or even fertility preservation? In this timely webinar, we will examine the question of whether prisoners should retain the rights to private and family life, the right to procreate, and whether restricting prisoners from procreating should form part of their punishment. And we'll have a look at what's practiced around the world. We'll dispense with the long bios and the contact information because the bios can be found on the site at ivfmeeting.com. I'm joined by my rock star ART attorney, or at least that's what they say about her, Colleen Quinn.
I don't know about that.
You can read her full bio on the site, but Colleen has over 3 decades of experience in adoption, personal injury, medical malpractice, employment, estate planning, and especially assisted reproductive technology law. She received her JD from University of Virginia and served as a judicial clerk to the Virginia Supreme Court. She's a fellow and past president of the Academy of Adoption and Assisted Reproduction Attorneys. She has so many awards and recognitions as an outstanding attorney. And she's joined by our superb panelists from both the lab and the bar. With us, we have James Lawford Davis, who's the UK go-to guy for legal things to do with fertility. He's a British solicitor, partner at Hill Dickinson in London. He advises a large number of clinics and hospitals, universities and researchers licensed by the Human Fertilisation and Embryology Authority, the Human Tissue Authority, and the Care Quality Commission. He's been involved in most of the leading cases related to assisted reproduction for embryos and for stem cell research. James has been involved in many cases in the UK courts. Much of his work concerns the judicial review of regulatory bodies and cases arising as a result of regulatory action. And finally, we are joined by Dr. Dawn Kelk, who has directed IVF labs in both Canada and the United States. She was previously the director of the IVF lab at Yale and associate research scientist at the Yale University School of Medicine. She's currently the scientific and lab director at Extend Fertility. Dr. Kelk's clinical and research interests are diverse, ranging from trophectoderm biopsy, PGT, vitrification of embryos, and oocytes, analysis of liquid nitrogen, cryostorage tank failure, laser impact on embryo biopsy, and predictors of endometrial receptivity. Dr. Kelk is a member of ASRM and the SRBT. And I encourage you all to please ask your questions using the Q&A section of the conference service and not the chat function.
Thank you so much, Lyndon. It is a pleasure for me to be able to now introduce Lyndon after he introduced those other amazing individuals. Lyndon is a highly accomplished lab director and clinic owner. He has worked in this field for over 30 years. We got a lot of long timers here. Lyndon has extensive experience, including 6 years as senior embryologist and Harvard instructor at Brigham and Women's Hospital, Harvard Medical School, Boston, USA. Lyndon is a co-founder of the CRGW chain of clinics, who have clinics in Wales and the southwest of England, including Bristol, Plymouth, and soon to be opened Exeter. Lyndon served for 5 years as a member of the Association of Clinical Embryologists Training and Examination Committee, acting at a national level as an assessor for new members of the clinical embryology profession. Without further ado, let's have an introduction to this unique topic that we are here tonight or today, depending on where you are in the world, to talk about. Lyndon, take it away.
Thank you. Okay, so hopefully you will be able to see my talk on screen. Yes, I'm talking about incarceration, planned pregnancy, and welfare of the child, and some of the extended possibilities of the assisted reproductive technologies that we do. I'd like to say a quick thank you to the wardens at I3 for allowing me 15 to 20 minutes of what is effectively yard time to give a talk on these type of things. Also, as my favorite movie is Shawshank Redemption, I get to live a little bit of it. I have plenty of questions, but maybe not as many answers. Firstly, why are we doing this talk in particular? I think it may have started out just in a conversation with one of the people from I3, where I was talking about being approached by a patient who wanted treatment with a partner who was incarcerated. And it seemed to roll on from there. So some of the questions I want to examine are, should the loss of freedom mean a loss of sexual or reproductive freedom? If prisoners are entitled to receive medical treatment regardless of their crimes, should this extend to fertility treatment? Do prisoners have a right to have a child? And do certain crimes make people unsuitable for parenthood? Should we offer gamete cryopreservation and even sperm or egg donation to prisoners? And what type of assessments can we do to help us decide? So the public perception, certainly on this side of the Atlantic, is almost entirely against doing fertility treatment for IVF patients, for prisoners who want IVF. And these are just some of the newspaper articles I've taken, many of which take issue with the fact that as taxpayers, we have to pay for prisoners to have IVF when there are some people who are not in prison who can't access it here in the UK. So the public are very against it, though politicians seem to have become ever more powerless to refuse access due to the European Court of Human Rights. I am going to talk about other countries, including the US, but some of this will be, of course, on the UK. So do prisoners lose their rights? They retain all of their rights according to the European Convention on Human Rights, except for liberty, so except for their freedom. And there's been many justice secretaries and politicians in the UK have tried to ban IVF for prisoners, but are largely unsuccessful. So we should take a look at a definition of liberty, which is the state of being free within society, and to be able to give your own views, your own political views, to not be imprisoned and have the power effectively to act as one pleases. I also wanted to look at some definitions of infertility, which of course the vast majority of people will know inside and out, but it's relevant to the talk. The ASRM discuss it or define it as a disease, an interruption or cessation of body function systems or organs of the male or female reproductive tract. The term interruption there, I suspect, is when there's a hormonal problem or a blockage, rather than, for instance, a 5-year custodial sentence. The ASRM also go on to say the patient or couple should have been trying to conceive for 12 months with regular unprotected intercourse. The World Health Organization used an almost identical definition, as does the CDC. So there's a very common chain of regular unprotected intercourse, which of course is very difficult to have when you're incarcerated. Here in the UK, if patients want to access NHS fertility treatment, which is funded by the government, they have to have been trying for 2 years of regular unprotected intercourse. None of these definitions, of course, make any recommendations about the provision of fertility services or non-medical barriers to pregnancy, such as being imprisoned. In the UK, we are protected by the Human Rights Act of 1988. Two articles in particular, Article 8, which respects your private and family life, and Article 12, which protects people of marriageable age to marry and start a family. And neither of these can be interfered with the government. So what is the UK's government stance? For healthcare in prison generally, prisoners get the same healthcare and treatment as anybody on the outside. So if somebody gets cancer, they get chemotherapy. And all treatment is free for prisoners, although there is an exception there for fertility treatment. They would only get funded fertility treatment if they met criteria and they are in the right zip code, postcode, which is how it works typically in the UK. So treatment is decided by a prison doctor or a member of the healthcare team. If the prison cannot treat the illness or the disability, which in the case of IVF or IUI would almost be entirely the case, they can either get somebody to visit the prison, or they can be arranged to go to an external hospital. So to look at a few cases, this is a case from the UK. A famous one from some years ago, a British murderer, Kirk Dixon, was granted to have IVF with his wife. At first, the UK courts viewed his procreative freedom as being lost by virtue of the fact that he'd entered prison. And initially, the European courts mirrored that same ruling, but they later went on to decree that reproductive freedom is not automatically lost when a person's imprisoned, and that imprisonment itself is the punishment, which didn't particularly or explicitly include the removal of the ability to have children. So there was no clinical need for this patient to need IVF. There was no cause of infertility. It was just a right to have a child. And as you can see by the pasted press article at the bottom, the British public was fully behind that. There are other cases around Europe. A case of a Spanish woman who was part of the Basque separatist group ETA, a terrorist organization, and had a 13-year prison sentence. She was granted bail to leave prison to have IVF, and that was funded by the Spanish government. Interestingly, at the time, she was 47. So it's difficult to argue what condition was being cured, and the likelihood of a success would have been very poor. And with no medical need, this again suggests this being her right to family. Sperm smuggling is a very common news story that we see around the world with prisons. Since August 2012, 30 women in the West Bank in Palestine have been successfully impregnated with their husband's sperm that has been smuggled out of Israeli jails. And there are two particular clinics in Nablus and Gaza who handle the vast majority of the smuggled sperm. How, we all wonder, in crisp bags or chips to the US audience, sweet wrappers, eyedropper containers, all sorts of things which are often shrewdly placed into the pocket of a child when the prisoner is allowed to hug their children. And an example of this is somebody called Ammar Ziban, who was in prison in Israel for terrorism, not seen his wife for 15 years. He had two teenage daughters on the outside. Not only was his sperm smuggled outside of the prison, but they then did sperm sorting on it to sort it into male and female sperm. It was enough to be frozen for 3 IUIs. The first 2 were unsuccessful. The third resulted in a son. And the Palestinian clinic saw it as a humanitarian issue, and that everyone has the right to be a parent, and that prison shouldn't stand in the way. And the term right seems to come up a lot with some of these cases. This is another couple actually who were both imprisoned in Spain, separate prisons, both members of the ETA terrorist organization, and they were both granted fertility treatment. And Jodra, the male, was moved to a prison local to a fertility clinic so he could attend there to bank sperm. And separately, his partner, Zarisolo, could then go there and have IVF with his sperm, and if she got pregnant, raise the children until 3 years old while in prison. There's also many examples of conjugal visits. This one in particular in Israel, Yigal Amir, who assassinated the Israeli Prime Minister. He put in a request to do IUI, which was refused, and tried to smuggle sperm out of the jail, which was thwarted, and was then granted a 10-hour conjugal visit with his wife. And because of that, they now have a son. And to some extent, the conjugal visits are a potential way forward in terms of there's a lot less risk and a lot less cost to the prisons. They're very popular in some of the countries around the world, some of the Scandinavian countries, France, Spain, Russia, Canada, parts of the United States. And there's evidence to show that it reduces reoffending, with some perception that it settles the prisoners and that it offers a privilege for good behavior and rehabilitation. It's been found that prisoners who have conjugal visits extend their relationships, which typically on average only last for 18 months from the point of incarceration. The only problem with the conjugal visits is whether it's the start of a process of normalizing prison and making it more like the outside world when somebody's actually committed a crime. Prisoners don't actually have to send their sperm out of prison to conceive, as in the example here, Ronell Wilson, who point blank range shot 2 undercover officers in the US. He then had unlawful sex with his prison guard, Nancy Gonzalez, who's now facing 15 years in prison. She did that in an attempt to save his life because he faced the death penalty, and it was believed that if she was pregnant, he would have been able to avoid it. He was always desperate to father a child, and he didn't want his life to be wasted, and was prepared to confess to the murders if he could do that. But she got pregnant in the interim time while in prison. Separately, there are also 2 prison guards from Pennsylvania who are currently facing a 20-year sentence for smuggling the sperm of inmates' wives and girlfriends, to inmate sperm to wives and girlfriends. And there are also some examples of babies on death row. A recent one in Vietnam where a woman on death row paid for a fellow prisoner to donate, in inverted commas, his sperm to her. She inseminated herself twice in her cell with a syringe and conceived. And the rules in Vietnam is that a woman cannot be executed if her child is less than 36 months old. So she's bought herself 3 to 4 years of extra life because of that. A more famous example is probably Ted Bundy's daughter, Rose, pictured here next to him. And she was conceived while he was on death row. Curiously, he wasn't allowed conjugal visits, but they went on anyway. Should prisoners be allowed to be donors, sperm donors, for instance? This is an example from New Zealand. A murderer, Carl Nuku, wanted to be a father, so wanted the option to be able to donate sperm so that his donated sperm would be used for IUI, and that he would therefore have children that were biologically his outside of prison. New Zealanders were very against the case, and there was a general feeling that somebody of his character shouldn't be having children, which is a contentious issue. The politicians there believed that it should be judged on a case-by-case basis, but that murder wouldn't make the cut to want to be a sperm donor. From another point of view, you'd have to consider how, if a child was born, donor conceived child from his sperm, and then they find out about the history of their donor, that could be somewhat unsettling in the future. A case from Australia, this is a serial gang rapist who was imprisoned for 21 years, and while in prison he got cancer, and he was allowed to freeze his sperm, and the freezing of the storage was covered by the Australian government. He's now left prison, and that sperm is available for him to use for future use. There's been a few freedom of information requests here in the UK to the Ministry of Justice, one of which was to ask how many treatments had been done with prisoners here in the UK. And the record is that only 10 applications for fertility treatment had been approved since the 1960s in the UK. So it seems to be a very rare occurrence here. Also, another freedom of information request was put into the prison service, asking for their policy, their protocol on how to decide whether a prisoner should access fertility treatment. The policy was actually written in March of 2021. And it stipulates that prisoners don't have a right to access fertility treatment or fertility preservation, and that they will be examined or assessed on their individual criteria, and that the policy differentiates between if they want fertility treatment, obviously to try and create a baby, versus one to preserve their fertility. And this is some of the points from it. From the first 5 points, the prison and the prisoner have to prove evidence of. So firstly, that they would be unlikely to conceive naturally or with the help of fertility treatment by the time they leave prison. Secondly, that the welfare of the child has been considered and no existing children would be affected. Thirdly, that all parties consent to the procedure. That's probably more in the case of treatment rather than fertility preservation, which is of course solo. The prisoner's family physician, the GP or the PCP as called in the US, would have to be satisfied that they're medically fit, and a regulated clinic by the Human Fertilization Embryology Authority here in the UK would have to have approved that they're suitable for this based on a welfare of the child assessment. Any costs are incurred by the prisoner in terms of being escorted to a hospital, transferred, risk assessments that are made, and even the treatment itself, unless they meet the criteria and they're geographically located such that they could access NHS treatment. The prisoner also has to consider whether doing the treatment is in the best interest and would it undermine public confidence in the justice system. that there would be no concerns from a safety point of view, to transferring the prisoner from the prison to the hospital, that the decisions made are discrimination-free, and that there are considerations for the Human Rights Act, the clauses 8 and 12, which I mentioned previously. So moving on to my last few slides, I guess, with welfare of the child. So the work we do here in the UK is covered by the Human Fertilisation and Embryology Act of 1990. And this stipulates that no woman should be provided with fertility treatments, including intrauterine insemination or artificial insemination, unless account has been taken for the welfare of any child who is born as a result of that treatment, including the need for supportive parenting and for any other child who's already alive to be affected by that birth. Treatment services is defined as any medical, surgical or obstetric service provided to the public to help them in assisting them in carrying the child. And we have a form. This is done for any patient having treatment. We start off by taking some demographic information. Then there's a whole range of questions that we ask the couple or the individual. And then we have to decide whether we need to seek further information. Do we need to take further action? Are we willing to offer treatment? And some of the questions that we may ask are things like, do you have any previous convictions relating to harming children, which would obviously be relevant to a prisoner? Are there any child protection measures against you regarding your children, if they have any existing children? Is there any evidence of violence or discard in the family environment? Does the person you're treating have any mental or physical conditions? Is the child at any risk of any transmissible or genetic disorders? Are there any drug or alcohol problems? And are there other aspects of the person's life which may cause a risk to any unborn child or any existing child? The process warrants that all clinics have a documented procedure for doing welfare of the child, that we assess each patient, and if they have a partner, their partner, again, making sure there's no harm to an unborn or existing child. We have to repeat any welfare of the child assessment if we haven't seen somebody for 2 years, if a patient has a new partner, if a child has been born since we last saw them, or if we have any reason to believe the medical or social circumstances of the patient has changed. We have to do this in a fair and non-discriminatory way. We have to verify their identity with a government recommended source of ID, like a passport or a driving license. And we have to take a thorough medical and social history of the patient, and if they have a partner, the partner also. And if we have concerns, we will do that separately. Factors that we consider to ensure there's no neglect: any past or current circumstances that may lead to harm to children, previous convictions relating to children, any child protection measures, any violence as previously mentioned, or any past or previous circumstances that may lead to the inability to look after a child in regards to those such things as mental or physical conditions, alcohol or drug abuse, a medical history where there's a likelihood that the child could suffer from a serious medical condition, and any circumstances that the centre considers likely to cause serious harm to a child. We also have to consider a definition of supportive parenting, which is a commitment to health and well-being of the child. We have to presume that the parents are supportive in the absence of any reasonable cause for concern. And where we have a cause for concern, we may need to go to the patient's wider family, social networks, or other medical professionals. In the assessment, we have to obtain consent from the patient, and if they have a partner, which enables us to be able to contact other individuals, agencies, the police, doctors, authorities, if we need to gather further information, and any information that suggests, again, that there may be harm to a child. If the patient has failed to provide any of the information requested, we have to take that into account, although that doesn't necessarily stop them being treated. If the information being provided by a patient and or the partner is inconsistent, if there is any evidence of deception, we have to look as to why that is. And if anything is told in confidence to any member of the staff that is treating the patient, we have to seek the patient's consent to be able to pass that on to other people. unless we feel there's a need to actually breach that patient's consent. We can refuse treatment if there's any risk to a child, if we cannot obtain enough information to prove that there is no risk. And we have to take into account the views of all of the staff who have been involved in seeing the patient. We give the patient, and indeed partner if they have one, the opportunity to respond to reasons for us declining their treatment, and actually get a chance to do something to make us change that decision if they can. We have to put in writing why we would decline their treatment, anything that they could do which would make us reconsider, any remaining options they may have other than the one that they're trying to pursue, and also an opportunity for them to receive appropriate counselling. So in conclusion, it's generally accepted that prisoners can access medical treatments. Therefore, if fertility warrants or is construed as a medical need, it seems somewhat unreasonable to deny access to prisoners, though arguably this should be done on a case-specific basis. ART doesn't neatly fit the paradigm of a medical need, because often with IVF there isn't a malfunction and therefore a cure. So it doesn't fit like many other treatments, like oncology treatments. And we also have to remember that no such judgments are made of non-incarcerated parents, some of whom it would be easy for us to question whether they would be suitable to be parents. And making a choice of who can and can't be parents does start to head down the questionable road of eugenics. If the point of the prison system is largely to rehabilitate the patient, then it should be maybe argued counterproductive to restrict the patients from these kinds of relationships, which would normally be central to normal human life. And although some people argue that prisoners should be restricted, there's no such justification to restrict a free person. Of course, we have to also remember, apart from the person who's in prison, they often are going to have a partner on the outside who hasn't done anything wrong, and you'd also be limiting their ability to have a child. So human rights, including the right to human life, are not just granted to people who deserve them, and they are granted to everyone, and we can therefore argue that that should possibly include prisoners. I'd like to make a brief acknowledgement to Dr. Mary Yarwood. I don't believe she's with us tonight, but in reading articles for tonight's talk, I read so many things by her or comments by her, it seemed unfair not to pay her some homage. And I'll leave you with a picture from the end of the Shawshank Redemption. Thank you for listening.
Linda, that was absolutely fantastic. There's a lot more sex and sperm smuggling going on in prisons than I think most of us ever realized. So I've got so many questions to ask you. I'm going to kind of combine a couple of them. How often are patients denied treatment because of that welfare assessment? And where are the lines drawn? What type of consideration do you give to the possible creation of future criminals for people that have had mental health issues that put them into the prison to begin with? I understand the protecting, the welfare of the child, but how are we protecting society from creating more folks that might end up in prison? How does that factor into that welfare assessment?
Sure. I mean, in terms of how many times do we decline patients due to a welfare of the child assessment, it's surprisingly infrequent. Maybe once or twice a year for every 500 patients you see, it would be that rare. What tends to happen is if one of the staff or a group of the staff take a potential issue with the welfare of the child assessment, we will then often meet as a group to discuss it and talk it out. And then we may, because of that, seek further information. So I would say ultimately it's very rare. It's difficult to make that decision, as I'm sure most people will appreciate, as to who can and can't have children. But of course, because we're playing a third party, we have a legal obligation, so we have to make that assessment for the child. In terms of, I think the suggestion of possibly propagating bad genes. I don't know if that's a way of
Oh,
looking at
that's a good way of wording it. I should have
by being in prison. And I think that's true in terms of when we look at the case of the New Zealander who was a murderer who wanted to be a sperm donor. I'd be very surprised if anyone would be willing to do that. And it's not implausible that people who are doing custodial sentences, maybe there is some type of genetic background to them being more violent or something like that. So I think that is the case. But again, I think it has to be judged again on individual merit, because this could be somebody who's in prison who'd made a stupid mistake and committed fraud, or you know, was drunk driving or something like that. And maybe the argument's a little bit different for them.
Yeah, absolutely fascinating. Thank you so much. That was wonderful. We are going to move on now to some of the lawyers, and it's my pleasure to introduce Will Claiborne. You can see his full bio on the site, but for now, I'm going to give a pretty abbreviated introduction to you, Will. Will founded the Claiborne firm in Savannah, Georgia in 2008, specialized in complex family law litigation, including custody, high asset divorces, and family building through assisted reproductive technologies and adoption. In addition, he leads his firm's civil rights practice, which is heavily focused on inmate rights to healthcare and safety while incarcerated. And we are really looking forward to hear you talk, Will.
Well, thank you, Colleen. It is an interesting nexus of the things that I do to be here today, and I'm really happy to be here and with everyone who's watching. My task in the next 10 minutes here or so is to talk about the general idea of healthcare in jails and prisons in the United States. So first off, everyone in the United States is protected by the Bill of Rights, the United States Constitution, and specifically the 8th Amendment to the Bill of Rights provides that everyone should be free of cruel and unusual punishment. And it took just about 200 years for the question of what is cruel and unusual punishment in the context of healthcare in jails and prisons to make its way to the Supreme Court. Because like any right in the United States here, that right is only enforced by going to court and suing someone. And in the case of inmates who are being denied medical care, they would and do sue either the warden or the sheriff or the medical provider at the jail where they are being held in order to enforce their right. But up until 1976, it wasn't clear what that right was. And in the case of Estelle versus Gamble, the United States Supreme Court weighed in on an issue of an individual who had suffered from a back injury while working under a work release program at the prison where he was incarcerated. And what the United States Supreme Court found in Estelle versus Gamble is that it violates the 8th Amendment and is a cruel and unusual punishment to deliberately be indifferent to a prisoner's serious illness or injury. And there's a lot to sort of unpack there, but the court again said that deliberate indifference by prison personnel to a serious illness or injury violates the 8th Amendment. And so that, of course, begs the question immediately, what is a serious injury? What is a serious illness? And so the case law has developed from there with individuals suing to enforce those rights. And then also note that what the court said was that they cannot be deliberately indifferent to those rights. And that's very, very different than in, say, a car wreck case where you can sue somebody who is negligent. They accidentally ran a red light and hit and injured a person. That's certainly more than enough to sustain a claim for personal injury under a car wreck case. But in a jail or prison environment, the court has said that you have to prove that the individual who is in charge of providing you with treatment was either intentionally denied you of that care or was so indifferent to your serious medical need that it can be presumed that they intended to actually harm you. So we have to, when we're suing on behalf of incarcerated individuals, we have to prove that the person in this hypothetical intentionally ran the red light in the jail, intentionally caused the harm to that individual. And it's very important to understand that that is a very high burden in order to show that. I say it in a shorthand way sometimes with our clients that folks who work at a jail or a prison can be stupid, but they can't be evil. So for example, a nurse who is providing medication can unintentionally give medication to one inmate that was supposed to go to another inmate. And provided that was an accident, then no matter what harm comes to the individual who took the wrong medication, they could die. And there would still be no viable claim that we could bring if the nurse in that case was accidentally provided them or negligently provided them with the wrong medication. Individuals who are in jails and prisons in the United States don't pay for their health care, and they are entitled to health care that meets the community standards of the community in which they are incarcerated. So a person who has cancer is supposed to get chemotherapy. A person who has a broken arm is supposed to be able to go and get that broken arm treated with a cast or surgery. However, you have to prove, as I said before, that they were intentionally denied that care. And then the other thing that we have going on in the United States in a lot of locations and jurisdictions is a privatization of the healthcare provided in jail. So of course, unlike in the UK and a number of other developed nations, we don't have a national health service here in the United States. And what a lot of localities have done in providing for healthcare for prisoners, because it's expensive, they hire private companies to come in. And oftentimes what we see is a contract that is structured to where a single pot of money, let's say $5 million, is given to a healthcare provider. And they're told, okay, with this $5 million, you take care of these prisoners that are held in this jail or prison. And what you spend on those prisoners, you spend, and what you don't spend, you get to keep as your profit. And so those providers with that contract have a dollar for dollar incentive to deny care. For every pill they don't give, they save that money. And when individuals have to be sent from the jail or prison where there's an infirmary and minor care can be provided, when they have to be sent to an actual hospital, then that care gets very expensive. And so then there's a major disincentive for those individuals to be sent out to those hospitals. I have for you, and I will warn you, the audio is low on this tape. So you may, when we start the tape, you may want to turn up your audio so you can hear it. But it's an example of an individual, his name is Matt Laughlin, whose family we represented. Matt was suffering from congestive heart failure in the jail here in Savannah. He had been sent to the hospital and diagnosed with an enlarged heart. And the doctor who saw him wanted to admit him to the hospital, but the jail wouldn't let him be admitted. And he was actually sent back to the Savannah jail. And after he had been sent back, he made a couple of phone calls to his father and to his mother. And we've got those put together for you so you can hear how this actually plays out. You may want to turn your audio up.
This call will be recorded and subject to monitoring at any time. Please enter your personal ID number.
I don't know what me or her or anybody else can do if they won't let you go to the hospital. I can't understand that. All I can tell you is that, I'll go down there Monday to the jail and talk to them or whatever it takes and see what I can find out why they want you to stay in the hospital. I thought when you was in jail, I thought they had to provide medical care for you.
I've been coughing up blood and everything.
I'm really sorry to hear that. You know that I love you, even though we're not very close together right now, but I do love you. I always have and I always will. I just don't know what I can do for you. It's something that's...
You can call up here and ask to talk to medical.
Ask to talk to who?
Medical.
I can't do anything like that till Monday. I've already talked to them. The doctor and everything's gone home for the weekend. They won't even talk to me or tell me anything without your authorization. They wouldn't even tell me. Oh, they tell me that you're alive.
This call will be recorded and subject to monitoring at any time. Please enter your personal ID number.
Okay, listen, I have found out everything I can. I'm going to try to get, I'm having lawyers and a sheriff and all this other kind of shit trying to make it so I can come in there and see you. I'm trying also to get you out of there and get you under.
I need to go to the hospital. I'm
I
going
know.
to die in here.
I know you are, Matthew. I'm doing everything I can to get you out. and so I can see you. Hello?
Yeah.
They're doing everything they can.
There are 15 seconds remaining.
I've been coughing up blood. My feet are swollen. It hurts.
I know, Matthew. I know what is wrong with you. I told you this would happen. I love you, Matthew. They're going to cut us off.
I love you too. I'm gonna die in here.
And unfortunately, Mr. Laughlin was correct. The last words that he ever spoke to his mother were, "I'm going to die in here." And he did pass away from congestive heart failure, which would have been treatable if he had been sent to the hospital earlier, according to the expert witnesses that we had in that case. So if life-saving medical care is supposed to be provided, but isn't always provided, and individuals have to sue in order to get that type of life-saving care, it's clear to us that elective care is never an option and is not something that one can actually sue under the Eighth Amendment in order to be able to enforce. The medical care that's provided or not provided in jails and prisons in the United States is, in my opinion, and the opinion of many civil rights lawyers in the United States, a scandal in plain sight of individuals being neglected and maltreated, such as Mr. Laughlin, and really very unfortunate and quite frankly, a stain on the United States. And I thank you for your time. We're going to move on now. I think there may be one question for me.
Thanks, Will. Thanks for your talk. That's fascinating, if not a little heart-rendering. I wonder if I could ask you, are there any examples in the US where a woman who's sent to prison, where it's considered that she's going to be in prison during her reproductive years? And would a sentence ever be changed due to that, to accommodate that?
We've seen cases where individuals, like a married couple, get convicted of the same crime and they have young children, and a sentencing judge may stagger their sentences so that one parent stays at home and deals with the small children, and then they switch places. I'm aware of circumstances like that. That would have to be at the sentencing phase, where an individual would make that plea to a specific judge, but there are no reported appellate cases that I'm aware of where an individual was incarcerated for the entirety of their reproductive years and brought a case on that basis. But a sentencing judge could defer someone. You have a year to report, or your husband goes to jail first and you go to jail second. That discretion would lie with the judge who's imposing the sentence at the time of the conviction.
Okay, fabulous, thank you. Actually, I wonder if James Lawford Davis could come in. I wonder if James has a view from the legal side on this side of the Atlantic, particularly in regards to, James, I wonder if you could comment on the ability of women to be able to, for instance, freeze their eggs while they're imprisoned in the UK.
Yeah, thanks. And thank you, Will. It was a really interesting talk. I mean, I'm not aware of cases as tragic or as difficult as the one that Will described in the UK. I think the difficult question that we face in relation to reproductive autonomy for prisoners is in relation to prisoners who face no infertility, but simply an inability to reproduce as a result of being in prison. And you described, Lyndon, the tests that are applied for people who are wanting to have treatment. And that would apply equally to women who wanted to freeze their eggs. In theory, there's no obstacle to that, providing they can fulfill the requirements and providing those requirements are applied reasonably and fairly. But we can come on to talk about that in more detail at the end.
Great, thank you, James. Okay, it's my pleasure then to move on and introduce Ruth Claiborne. Again, please check out the website for her bio, but in brief, Ruth has recently retired after a distinguished 40-year career representing prospective parents and other participants in family building via adoption and assisted reproductive technology. Her career milestones include the first to complete a co-parent adoption by same-sex couples, one of the first attorneys in Georgia to successfully handle surrogacy matters, a primary author of Georgia's embryo donation statute, and first to obtain pre-birth co-parent orders for same-gender couples in co-IVF and surrogacy cases. So it's my pleasure to hand over to Ruth, who will talk about autonomy in procreation, parentage, and the child's best interest.
Thank you, Lyndon, and thank you, everybody. My background is meant to convey something different than Lyndon's. It's meant to convey that I am on the outside. And I'm joined in this talk by my son, Will Claiborne, who you've already heard from, obviously. We're going to go through whether or not there's a constitutional right to procreate in the United States. If there is such a right of procreation in the United States, is it lost or suspended during a period of incarceration? Is there a role that cost and burden would play in whether someone would be granted that opportunity? And finally, are there some other avenues that prisoners might pursue in order to procreate, such as state laws, some sort of voluntary action on the part of the warden, or clemency, that sort of thing. So let me jump in with a thing that I imagine everyone on this call has heard about. On June 24th of this year, the United States Supreme Court overruled Roe versus Wade, a case that's been in effect in the US since 1973 that allowed women the right to choose abortion under some particular guidelines. There was a trimester analysis wherein the state would not regulate other than just the bare minimum during the first trimester, that there could be more regulation during the second trimester, and regulation up to prohibition during the third trimester of pregnancy. Well, that was overruled in Dobbs versus Women's Healthcare. And the rights enumerated in Roe versus Wade were based on a number of constitutional provisions, none of which directly state that there is or was a right to abortion. It was, the several different parts of the Bill of Rights, the First Amendment, Fourth Amendment, Fifth Amendment, Ninth and 14th Amendments, that taken in total, the justices in 1973 believed created an implied right of privacy. And later in 1992, as challenges mounted to Roe versus Wade, the Supreme Court held in Planned Parenthood versus Casey that liberty is another factor here, that the 14th Amendment due process clause implies that there is a liberty and a personal autonomy in these decisions. Once again, this is not specifically enumerated in the Constitution, and yet I think that the majority of people in the United States, whatever their, well, I would venture to say that whatever the opinions are on abortion, and there certainly are many people, there have been huge political movements opposing abortion, but whatever one believes about abortion, I think that most people were prepared to say that we have liberty, that we have personal autonomy in matters involving our own bodies. And quite honestly, that whole area of liberty has been thrown into question and destabilized. The justices in this recent case said that you don't have any substantive rights to due process unless they are specifically enumerated, or substantive rights to liberty or autonomy, unless they are specifically spelled out in the Constitution, or unless they are deeply rooted in the nation's history and tradition and are essential components of ordered liberty. Whatever that may mean as time goes along, I don't know, but many of us are profoundly unsettled by the loss of a woman's right to choose, and profoundly unsettled by what future implications of that might be. Prior to this decision, there was one case on point called Gerber versus Hickman that was decided first in California in a district court and later on appeal in the Ninth Circuit, which is the most progressive circuit typically in the US. And there was a prisoner, an inmate, who had a life sentence on a violent crime. He wanted to ship his sperm out of the prison in order to impregnate his wife, and that was denied by the prison officials. The issue of conjugal visits came up, and in California, the prison did not allow conjugal visits for people sentenced to life unless a parole date had been set. Now, this case was decided, if I didn't mention before, in 2002, so it's a relatively recent case. And the court grappled with the constitutional rights versus presumably if there is a constitutional right to procreate, then now let's move on to the question of whether or not that is one of those constitutional rights that gets suspended during a time of incarceration. And that court held that incarceration is inconsistent with many of the attributes of marriage, that marriage is a right that incarcerated individuals have, but they don't have a right to live with their spouse. They don't have conjugal visits. They're separated from personal intimacy, and they're separated from bearing and raising children. So that was the holding in that case. And in the dissent, there were some interesting points made. Some of the dissenters found that issues of cost and inconvenience to the prison had been considered by both the prison officials and by the courts. They found that to be repugnant. They said that the dissent said that collecting sperm for insemination is functionally really no different from collecting DNA to be used as evidence on appeal for possible exoneration from the conviction of a crime. And we'll get to that later on. I think that is not an entirely informed statement on the part of some of the judges in that case. So that's a kind of a nutshell of those cases. And I'd like to turn this over to Will for a minute to just talk about those constitutional rights that are held and not held during incarceration.
Right, and thanks, Mom. And it is interesting, of course, that the right that we're talking about here, the right to create a family, is not specifically enumerated in the Constitution, just like the rights that you're talking about that have now been destabilized with the recent Dobbs decision overturning Roe versus Wade. But there are, of course, 10 articles of the Bill of Rights, and then the 14th Amendment and other amendments that have been enacted to the Constitution, which give us very explicit rights: the right to free speech, the right of assembly, the right to keep and bear arms, free exercise of religion, things of that nature, the right to vote, serve on a jury. All of those are rights that, depending on the conviction that gets suffered, individuals lose those rights. So for most felony convictions in most states in the United States, that you lose, at least during the time of your sentence, the right to vote. During the time that you're incarcerated, you lose your right to protest. You can't get together a group of people and protest in a jail. You lose your right to freely assemble. And you lose, for felony convictions in the United States, your right to keep and bear arms in perpetuity. And so there are a number of these rights that are immediately taken away, only some of which are restored. The vast majority of states, but not all states, restore the right to vote upon the completion of a felony sentence. In some states, you have to actually petition in order to get that right reinstated, and in some states, it's never reinstated, 3 of them. So it is an interesting question if there is, and we know it's not explicitly stated, but if there is this right to create a family implicit in the Constitution, is that one of those rights that's lost? And there's, to our knowledge, been no case that directly addresses that on point, with the exception of the case that you were just referring to from 2002, the Gerber case.
There have been a couple of cases that have said that involuntary sterilization is no longer allowed. But I would not say that that is the same thing as the right procreate, because procreation might be, you know, at a moment in time. Sterilization would take that away permanently. So I do think that there is some distinction. Let's move a minute to some of the practicalities. Would a jail or prison be likely to allow female inmates to receive sperm from their spouse or partner on the outside, or from a donor? And I want to say out of the gate, I think, again, this is more of a practical issue than a constitutional issue in terms of how it plays out. But the burden of pregnant inmates is already a big issue for prisons, and especially in the context of the cost of healthcare and privatization and so on. Many women do enter prison already pregnant. Sometimes women are impregnated while in prison through illicit activities such as guard inmate activity. When it happens, they deal with it, but they have not always dealt with it gracefully, to put it mildly. There is a recent statute that passed in Georgia that forbids the shackling of women inmates while they're pregnant, except for absolute necessity, security. So it used to be fairly common practice that when taking a woman inmate outside of the jail or prison for a prenatal appointment, she might be completely shackled with handcuffs behind her back, chains around her waist, and cuffs around her ankles, totally shackled. This particular case that led to the enactment of this new statute, a pregnant woman who was shackled, tripped, fell, and miscarried, lost the baby. So that was the impetus for the Georgia legislature to pass a law banning shackling. But even this law still allows that a woman in active labor in a hospital can have her hands cuffed to the bed during labor. So the treatment of female inmates while pregnant is not at all humane in many cases. What happens when the baby is born? In many cases, the child is taken from the mother within hours following birth, and there's no opportunity for breastfeeding or bonding or any such thing. Now, this will vary from state to state. It will vary from jails and prisons, but the most common scenario is that very soon, by the time the woman is released from the hospital back to the jail or prison, the child essentially becomes a ward of the state. The first thing that the family and children's services, the child welfare authorities, will do is look for relatives who can take care of that child. The woman, of course, would have been given an opportunity to name family members, friends, or relatives who might be able to take care of the child. And if found suitable, that's what would happen. But if there is no suitable family member or personal contact, then some of these infants go straight into the foster care system. So given the additional costs and the burdens of high-tech treatment, also, if we're talking about allowing women to retrieve eggs for preservation or of fertility or future family building, once again, I would say it's unlikely. And we can talk about that some more toward the end when we sum up some of the more sympathetic versus very unsympathetic situations. Will, talk about men.
Well, yeah, and one thing I would say, just circling back to what you just said, jails and prisons hate pregnant inmates. They're incredibly expensive, and we've handled a number of cases where women did not get appropriate prenatal care or were refused referral to a hospital and ended up giving birth in their actual jail cells. It's a real problem. Now, in terms of, if we go the other way and say we've got a male inmate who we want to take his biological material, and take his sperm and transport it to the outside, Well, first of all, the jail doesn't have a mechanism in place for someone to just send something out. Jail mail is highly regulated. We're seeing a vast move now that there's no in-person visitation at all between an inmate and their family members, no opportunity for any contact. You get video visitation where an individual is on another side of the entire jail facility. So the idea that we're going to be able to have somebody retrieve in a sterile environment the semen sample, be able to place it in any sort of the mail or a delivery system to get it to the outside in the window that it would need in order to be able to be frozen or used, we just view would be highly unlikely. I have individuals who they're requesting medical care, and those requests for medical care get picked up every 12 hours outside of their cell. So this is the sort of reality that we're talking about. So you would be looking at a situation where the prisoner would need to be transported to a lab, which they're highly unlikely to do due to the cost of the security that would need to occur. And then again, this question going back of, is this a serious medical need? Is this a serious illness that this individual needs to actually get to this lab in order to be able to provide their biological material in this clean and sanitary environment, which takes us to our next topic that you had put down for us, Mom, about the FDA and the regulations.
I'm going to be curious if any of the embryologists have a comment on this, but the FDA, which is the Food and Drug Administration in the United States, enacts regulations, and one of those regs called 1271 deals with human cells and tissues, and it deals with all kinds of cells that have to be manufactured or processed or stored in some way, and there are very specific regulations that relate to reproductive cells and tissues. And so essentially, if we assume that sperm is going to have to be cryopreserved because of the time lag, from my reading, and again, I'm curious what the embryologists say, but from my reading, if an inmate produced his own sperm and handed it off, after about an hour or so, the efficacy of that sperm would start to drop, and it would certainly have to be cryopreserved in something other than your home freezer, right? It has to be done in very, very specialized equipment and very specialized ways, down to, I don't know what, 135 minus 135 Celsius or something. I don't know. The embryologist can tell us, but the point being, this sperm, it seems, would have to be collected in a specialized lab, and there are rules about collection to prevent the transmission of diseases. There are rules about labeling. There are rules about storage. There are rules about biohazard and not contaminating any of the other material that is located there. So you get the picture. It would be a daunting prospect and unlikely that a male inmate would be transported to a lab to go through this process. Even less so that a female inmate would be transported on multiple occasions to a reproductive facility for evaluation, stimulation, monitoring, receiving drugs to retrieve eggs, and going through the retrieval process itself. So I think going back to that original case from California from 2002, where it was stated in the dissent that this process is just like retrieving any other DNA for evidence, I think not. I think that was maybe a bit of a lack of sophistication about what happens.
Well, let's quickly, Mom, turn to the most, what we think is sort of the most best case scenario that we were able to come up with, and so we can get to the Q&A. But the best scenario that we were able to come up with would be a male inmate who has cancer, who is going to lose his fertility based off of those cancer treatments. At that point, we think that you could make the argument that that person is clearly suffering from a serious medical need, the cancer, and that cancer needs treatment, and that itinerant with that you could make the argument that that person should be able to preserve their fertility or would need to preserve their fertility. And based on the common medical procedure on the outside for other individuals who are not incarcerated, that it would be common and within the standard of care for that individual to be able to preserve his fertility prior to being able to undergo the chemotherapy. We have some other esoteric ways that we think that we could get there, but I would be willing to sign my name to a pleading where I cobble together an argument that that individual suffers from a serious medical need, that refusing to provide preservation for his fertility would fall below the standard of care, and that it would be deliberately indifferent to his medical need to prevent him from being able to do that. Like I said, we've got a couple other more esoteric ways that we think we might get there.
Let me add here about female inmates too. I think the same principle would apply to preserving the fertility of a female inmate. It's just that it's a lot more expensive, and unless she can afford it, or get a grant from a foundation or a GoFundMe or whatever, unless she can pay for that, I don't think that. And for that matter, I think the additional cost of preserving his fertility would have to come from private sources.
Well, it is worth noting that you cannot use your private health insurance or privately pay when you are incarcerated. You are completely beholden to that system. So even if you're willing to pay for your separate treatment, that you're not able to do that. So I think that there would be a big issue that the defendant would make if I sued them, that it would impose a huge burden on them to transport, particularly the female inmate, as you said, for the daily injections, the monitoring, the blood work, the ultrasounds, all those things that go into fertility preservation for women. But we're excited to get to the questions and answers. I'm sure there are a lot of them, and we're really happy to have the opportunity to talk with everybody.
And Will and Ruth, what a fantastic mom-son team, and happy birthday to Will. And
special thanks to Mom for me being able to be here today. It is in fact my birthday today.
Yeah, great birthday talk. So speaking of birthing, I think we might be seeing a bit of a difference between the United States and the UK, and with the United States really kind of moving in the direction of not being as humanitarian. And so I don't know, Will and Ruth, if you're seeing what I'm seeing, but I'm seeing, especially with COVID, that more and more facilities are unwilling to issue transport orders to bring incarcerated persons to prison even, and they're doing more and more video hearings. And I'm seeing this kind of cost savings, which tells me if they're not going to bring them to court, are they going to bring them to are they going to bring them anywhere else?
It's the excuse for everything now, is COVID. We can't do that in a pandemic. Well, you're choosing to incarcerate people in a pandemic. The only benefit that I've seen with respect to that is that it has led to a substantial amount of decarceration. Individuals that would otherwise be held on low offenses or with bond amounts that were crushingly high. And it's worth noting that high bonds do not ensure individuals show up for their court hearings. That there's been a lot of social science on that, but we've seen a lot of decarceration. It's the only benefit, but it has been a major burden for getting individuals' cases resolved, getting them medical care and things like that. It's a go-to excuse, of course.
I agree, and we are not seeing expansion of rights in areas such as healthcare and procreation. I think that when we try to look at the best case scenarios, we're going to find that there's been voluntary action or clemency of some sort. The person, committed a nonviolent crime, they're nearing the end of their sentence, and there are some extenuating circumstances in their favor.
So
and they have strong advocacy.
Yeah, I mean, thanks, Ruth. So we're going to open it up to Q&A, and I was going to ask James, we're seeing this kind of further and further restriction on incarcerated individuals in the United States. What are you seeing in the UK? And we already heard Lyndon talk about how it sounds obviously better to be a prisoner in the UK than it does in the US.
Yeah, well, there have been a number of really notable cases like the ones that Lyndon mentioned, which have, I suppose, reassured or reinforced prisoners' rights in terms of access to treatment. I think one thing I would emphasize though, and I noticed this in some of the questions in the chat, is that none of them constitute a right to have a child. So no court in the UK or at a European level has said that anybody has a right to a child, only a right to fair access to treatment. And even the right to respect for your private and family life, which covers reproductive autonomy and reproductive rights, even that can be qualified by the state, but it has to be proportionate, it has to be reasonable. And then in the cases that have gone to the European Court, they found that the interference by the UK government to restrict access to treatment for infertility wasn't proportionate, which is why those patients were eventually able to proceed with treatment.
And what are you seeing in the UK in terms of conjugal visits being allowed? Because I think Will and Ruth would agree with me. I think that's pretty much had the quash put on it, especially with COVID being used. So what are you seeing, James, in the UK?
To the best of my knowledge, that's not something that we've entertained in the same way as has been allowed elsewhere, but we have made other forms of assisted conception available to inmates.
Dr. Kelp, can you talk a little bit about the cost of the egg retrieval, et cetera? Because in the United States, it's obviously a hurdle, as Will talked about. So I think you're still on mute if you want to. There you go. And we'll take you. We'll hopefully we'll get you out of the prison there by the end of the show.
Yeah, see if you can get me out of prison. Before I get into the egg freezing, I just wanted to follow up just a little bit more on Ruth's comment about sperm freezing and sort of the logistical practicality of that. And it's interesting because logistically, years ago, people would have had to produce a sample. It would have had to been fresh at the clinic. And there is culture media, which is basically a sperm extender media that's been around for years. But there are actually companies in the US that are starting to offer the service, and you can literally, with a collection kit, collect that sperm sample and FedEx it off overnight, and they can freeze the sperm, and it's still quite viable. When I was in graduate school, I actually used some of that same media with sheep sperm, and I held it in the refrigerator for like 16 days, and there was still plenty of motility. So that media is
out with that sheep sperm.
Yeah, I used it in my previous life. I did IVF with sheep, goats, and cattle. So that's where I got my start.
That might be even less desirable than prisoner sperm.
Yeah. But the point is, it's interesting because there are actually companies out there offering that as a service. So it's actually much more accessible to freeze sperm now. It's not, for a couple $100 kind of thing. It's not insanely expensive. Egg freezing, there are more and more, the cost is coming down. I would say probably on average across the US, you're probably talking about $5,000, but then probably also the cost of drugs on top of that. So, but there are certainly clinics offering lower and lower cost egg freezing. And then of course, there's the ongoing cost of storage for any frozen specimen, whether it's sperm or eggs, which varies a lot. It can be anywhere from, maybe as low as 150 up to like $1,000 a year kind of thing.
And what do you all do if somebody that's incarcerated can no longer pay the storage fees?
Yeah, that I think is more a question. I thought that was a really interesting question in the Q&A, and I think that needs to go to Will, because can you read the exact question? Because I think the way it was worded was really good.
It's by Betsy Caro, the director of CryoGam Colorado. She asked, what are the rights of the cryobank to discard specimens of an incarcerated client that cannot pay the yearly storage fee?
Well, I mean, I guess I would go to the contract in that case, the contract between the individual and the clinic, because there's no right for the individual who's incarcerated to, force the government to pay for them to get the treatment and then to provide for the storage during that time. And so from that perspective, there's no way for the incarcerated individual to force the government to pay the clinic. And the clinic can't be forced to just keep providing a service that they're not being compensated for at all. And so in that case, that would be a contract between the individual whose specimen is being frozen and what their rights are there. And presumably those contracts would read that a failure to pay would be a breach of the contract and would no longer obligate the clinic to preserve the material.
And Will, I think that's great. But the reality that we're all living with in the cryo world and in our fertility clinics is that we all think that we should be able to just discard this stuff, but when it actually comes to throwing away somebody's sperm or embryos, especially now with the Roe situation, and even eggs, I mean, the reality of us actually doing that, we don't really want to have to deal with you and your friends to go to court and like deal with this stuff. We just want to like live in our little lab world.
Now, to be fair, my grandmother made me promise when I went to law school that I wouldn't sue any doctors.
Nice.
And with limited exception, I have kept that promise, the exception being when they mistreat incarcerated individuals.
Fair game.
But anyway, yeah, I can certainly understand a litigation risk and a concern. But I do think that what that would come down to is what does the contract provide? You know, between the individual and the clinic, there would be no real government involvement there that I see.
Yeah.
We've got some interesting commentary. Allison Bartolucci says she works in an art lab that's an affiliate of the state healthcare provider for the state prisons. We have frozen sperm from prisoners who've been diagnosed with cancer or other illnesses that would impact their fertility. The prisoners have been brought in shackles, unfortunately, to our facility with guards that accompanied them and waited outside the production room. And in all cases, they were prisoners in low security facilities. Of interest, the state pays for the semen analysis, the cryopreservation process, as well as the annual storage fees. We've not encountered any female prisoners with similar cancer diagnosis seeking oocyte preservation, but I assume they exist. Presumably, they are not offered this service due to the logistics outlined by Ruth. And I guess what we're kind of looking at is the aspect of the cancer aspect seems to be the cancer treatment potentially is a life-threatening event. Maybe that might tip the scales a little bit more toward the fertility treatment, but not leaning so much toward the fertility preservation. And Lyndon, you talked a little bit about that, the distinction between the treatment as opposed to preservation, the treatment being the foremost goal, the preservation kind of being a kind of a secondary outfall of that. Is that kind of consistent with your experience?
Yeah, absolutely. I mean, to be honest, when I read Alison's comments, and I was actually quite surprised because when we first started talking about this, I contacted a few colleagues over here in the UK, and there were some people who had very rare treatments or cryopreservation for incarcerated individuals who were brought to the clinic. Whereas in Alison's view, she seems to have seen that more regularly. The one question I had actually for James on this one is that when the freedom of information request to the prisons in the UK was done last year, and they said that only 10 cases had been accepted since the 1960s. Well, given that I've seen a couple which we didn't end up treating, and given that a lot of colleagues I have got various examples of prisoners coming to their clinics, is it that number's wrong, or is it that they're not collecting the data, or is it underreported? Is there some reason that the number is not greater than that, or do you think that's genuine?
Well, I don't know is the honest answer. It sounds unlikely to me, because purely anecdotally and in terms of the number of cases I've advised on, that would be a significant proportion of those 10. So it doesn't, to me, sound correct. I suspect it's more to do with the way in which that data is reported, because FOI requests, they can only go to the data that they've been given. So I suspect it just goes under the radar most of the time.
Lyndon, we're not familiar with this concept, but what is a Caldecott guardian that you have in the UK?
So a Caldecott guardian is every medical facility that collects people's notes or confidentiality or confidential documents has to have a Caldecott guardian, and it is their responsibility to ensure that these documents remain confidential. More importantly, they have to make a decision of when the documents should not be confidential anymore. In the case, for instance, where we may have to contact the police about a concern with perhaps a welfare of the child issue. So it goes down to that one person to make that decision as when the right or wrong time is for that patient's confidentiality to effectively be breached.
So here's an interesting question, and this probably goes to you, Dr. Kelk, but what background checks are being done on donors, gamete donors, with regard to, I mean, I know we have the ASRM guidelines with regard to gamete donation that do look into criminal history, but how does that play out in practice in your clinic?
Yeah, I don't think, I mean, generally there are health questionnaires and all of the, sexually transmitted disease testing. So we're doing stuff like, hepatitis B, hepatitis C, HIV screening. But there are also even questions, healthcare questions. There's supposed to be a physical, but the healthcare questions are even things like, did you happen to travel in the UK during the time of mad cow disease? Or did you, if you're a man who's had sex with another man, that's a preclusion for eligibility determination for gametes. And so they do have those kinds of screening questionnaires, but a lot of it is, how honest is the person answering the question? It would basically, the FDA says you deem your donors to be either eligible or ineligible. So if they meet all of the screening criteria for the sexually disease transmitting, genetic screening, all of that kind of stuff, then they would be eligible. And so to be an anonymous donor, for eggs or sperm, you need to tick all the boxes. You can use a donor, and there are loads of same-sex female couples that may have same-sex male friends that donate sperm. And you can use those donors if it's a known situation, and you just sign a waiver that says, I acknowledge that this doesn't tick all the FDA boxes. So that's sort of what the FDA, basically the FDA really cares. They don't care what's happening with sexually intimate partners. The FDA cares about when you're taking tissue from one person to another, and they want to limit the disease risk. So that's really what this is all about. They don't want to, if you're transferring a kidney, they don't want to transfer HIV with the kidney and put the recipient at risk. So they basically apply the same things to eggs and sperm.
Lyndon, Fran Farley asked this question. I think it goes to you. Do you think patients actually answer the wellness assessment honestly? And is there anything to back check? And maybe that's one for James as well. But how do you determine that they really are answering honestly?
It's a very good question. I think you have to go into the discussion trusting the patient. During the discussion, there may be things that you pick up from them, which maybe makes you question what they're saying. Also, because we contact patients' family doctors to get some history from them. So, there's been cases of us perhaps contacting a doctor and finding out that a patient has been sectioned for a mental health condition, which they didn't tell us at the time. So, I mean, for sure, they could to an extent deceive us, but then that's true of any consent in any medical procedure almost. And I think we just have to do as thorough a welfare of the child assessment as we can do, taking everything into account. And if we're as thorough as we can be, and they're still keeping something hidden, I don't think there's a great deal that we can do about that. We can't look into a crystal ball, unfortunately.
Right. As part of that assessment, though, do you get their full criminal background? Is there a look?
We don't, unless there isn't a mechanism by which you could request that on every patient. If a patient admitted during the process that they had been incarcerated, or that they'd just left prison or something, then yes, we certainly would. But otherwise, there isn't a process. It's easy for us to find out the medical history from the GP, from their primary care physician, but the same process doesn't count for prison record.
So I know in the US with regard to donor gametes and also the use of gestational carriers, doing background checks, even bankruptcy and child protective service checks, et cetera, is a pretty big part of, I know what my clients want in assuring themselves, with regard to that donor or that carrier, that there's nothing in their history that's going to cause them any concern. James, what do you see in the UK with regard to concerns about criminal backgrounds?
Well, it's an area that makes me very uncomfortable. I've always been concerned about the welfare of the child requirements as a matter of law. I think it goes without saying that all medical professionals and others involved in making treatment decisions will always take into account the interests of their patients, but asking them to take into account the interests of a non-existent potential child, I think is going a step too far. In terms of criminality, I'd be particularly concerned about relying on that solely, unless, and this goes back to the very beginning where Lyndon put this up, unless it constitutes a significant risk of harm to children. That's when it may become relevant. But the fact that somebody's been caught speeding or is just not a very nice person doesn't, to my mind, justify refusing access to assisted conception. And although we've been talking about different sorts of challenge, I think any patient that was refused treatment solely on the basis of the fact that they had a criminal record would have a very strong case to challenge that decision.
Can I just ask a question for Ruth, if I may? Ruth, are you familiar with any scenarios of where an inmate already has frozen eggs or sperm in an IVF clinic, and in those cases, should treatment still go ahead? So if we have an incarcerated man, should he be allowed to have treatment with his partner on the outside with his frozen sperm? Likewise, if a woman has frozen her own eggs before she goes to prison and she has a same-sex partner, should her same-sex partner be able to use her frozen eggs while she's incarcerated?
Thank you. That's an interesting question. And I think, yes, I have no hesitation in saying that the barrier is obtaining this kind of treatment or obtaining the kind of contacts that would be necessary while one is in prison. But if they have the foresight and the opportunity to preserve fertility before they go to prison, then I think that that material is protected and their partner could go forward.
So I just have a quick question. Are you seeing in the UK women that go into the prison system with pregnant or somehow get pregnant while they're in the system? Are you seeing an increase, especially in lower security systems, where they're actually able to keep their infants and care for them up until like the age of 2? I know it's really state by state dependent in the United States, and there are some states that are kind of leaning more toward that model, with especially knowing that the child has to ideally bond with the mom, have access to breast milk, that sort of thing. But what are you seeing in the UK?
There are some hospitals, some prisons now which have a separate wing for mothers who can have their babies with them, which seems to have been greatly welcomed by the population. There's only one potential downside that's been reported, and that is that there are some women who have been charged with a crime, and while they're waiting for their sentence, they are then intentionally trying to conceive, so that they get, I guess, better surroundings, for want of a better term, a better room, better facilities. So I think it's open to being abused a little bit, but certainly it is something that's increasing, and we're seeing more in British prisons.
So I think we're about to wrap up here, but James, wanted to ask you about kind of your views on what's going on in the States with the Dobbs decision and the overturning of Roe versus Wade. What is your take on where we're headed here. and how can we get some help? How can we get some help?
big question to finish with. Well, it's, gosh, I'm probably not best placed to comment on US law, but it's the latest of a number of examples of, I suppose, the politicization of the human embryo in the US, which as an outsider, I find really difficult to understand and to reconcile with where we are in the UK. We have had similar arguments in Europe in the past about embryonic stem cell research, where that is a political hot potato, and so there have been attempts to try to restrict the use of embryos for research purposes. But in the UK, we have such a robust, strict regulatory system that it's very different. There's a compromise inherent in that. So we allow research and we allow the creation of embryos in vitro and we allow the destruction of embryos, but we subject it to really tight regulations. So it's always subject to oversight and inspection and reporting and so on. So having made the decision that we will allow terminations, embryo research, IVF, I don't see that changing at all here. And maybe regulation, national regulation in the States would be a way of introducing some sort of stability, because the unpredictability now for women and families in the US must be unbearable.
And that's a great point. And as insiders, we're perplexed ourselves. But Will, do you think you might be defending some embryologist manslaughter cases down the road?
I mean, I think unfortunately, you look at some of these laws, I think, and I believe it's the Texas law, but they had these, automatic laws that would go into effect if Roe versus Wade was overturned, and the Texas law dates back to 1925. And so you certainly cannot assume that any law that was crafted at that time has any sort of bearing or understanding of what the medical science would be right now. And I think it's incredibly patchwork, very difficult to know whether somebody can cross state lines in order to seek out care that would be not legal in the state of their residence, but is legal where they're receiving the care. You're going to see an intersign war here between, blue states and red states over trying to criminalize each other's behavior and laws. And it is incredibly destabilizing to patients, to clinics and providers. And as a lawyer, obviously we'd be more than, I hesitate to say more than happy, but that's the sort of fight that we'd be willing to pick up to try to assist in those sort of circumstances, because it's just completely inappropriate, as James was saying, the politicization of people's reproduction and embryos. It's, at least in my personal view, not the role of government, but we are where we are.
Okay, wonderful. I think that probably brings us to a conclusion to what's been a fascinating group of talks and discussion. We'd like to thank everybody for attending the talk, and all of those who took part in the webinar, to Colleen Quinn, to James Lawford Davis, to Dr. Dawn Kelk, and together with speakers Will and Ruth Claiborne. Not forgetting, of course, the team from I3. Thanks to the organising committee of the initiative I3, and that's Jacques Cohen, Peter Nage, Marianne Chevetes, and Thomas Elliott and Giles Palmer.
And thank you also to the amazing Lyndon Miles. Great job. Really appreciate your presentation. So thank everybody for joining us, and join us again after a short summer recess. I'm going to put down my gavel. I don't know if you can see it. Put it up here to my face. What happens when you have a virtual background? You can't always see everything. If you do want to follow the website, www.ivfmeeting.com, or use the membership app to keep in touch. Don't forget the I3 podcast on the site, or from wherever you get your podcast from. The next webinar will be on the 7th of September from RBMO. So you want to stay tuned until we get to that point. And so we are going to recess for the summer break here. And in doing so, I'm going to hand down my gavel. We are adjourned. Thanks, everyone.